let's look at the Alex Jones verdicts. The plaintiffs had a not so great day when they got the $4 million and change compensatory damage verdict, but they had a much better day when they received an over $40 million punitive damages verdict. But there are three problems I see with this punitive damages award. The first involves the cap that everybody's talking about. In Texas, generally, there's a cap on punitive damages. Aside from the Texas statute, the United States Supreme Court has put some limits on how large a punitive damages award can be in relation to compensatory damages. I'm going to leave that out of the equation and just look at the statute that is probably in play here. So in Texas, the statute says if you can prove that you're entitled to punitive damages, there's a limit on that, subject to some exceptions. The limit is 2 times economic damages, and if you have non-economic damages, an amount equal to those up to $750,000. So what was the case here? The case here was that all the compensatory damages were non-economic. Let's look at what the jury awarded. For the first count of defamation involving Neil Heslin, the jury gave him $50,000 for past reputation injury, $10,000 for future reputation injury, $50,000 for past mental anguish, and $0 for future mental anguish. Under the Texas statute involving punitive damages, non-economic damages specifically includes injury to reputation. So all of this stuff relating to defamation, injury to reputation, that's covered as non-economic damage. You'll see right before that, too, when it talks about mental anguish, the statute says that non-economic damages include mental or emotional pain or anguish. So both of the type of damages awarded in the first cause of action on defamation are compensatory, but they're non-economic. Economic would be, I spent $1,000 on therapy, give me this money back. But that's not what they awarded for. They awarded on the non-economic damage to reputation and mental anguish. The larger awards came under intentional infliction of emotional distress. They were equal for both the plaintiffs, which is Neil Heslin and Scarlett Lewis. That was $1.5 million for past mental anguish and $500,000 for future mental anguish. So mental anguish is right there in the statutory definition as a non-economic damage. So this makes it a little easier to read the statute because there are no economic damages to consider. There are only non-economic. So if the cap applies, that's $750,000 essentially per plaintiff, right? So let's get into the statute. I've heard some people say, hey, the cap doesn't apply if it was a result of malice or something like that, or recklessness. I don't see that in the statute, and maybe I'm missing it. I just don't see it. As a matter of fact, if all it required was this heightened sense of mens rea, like you had to do it on purpose or malice, then there really wouldn't be a damages cap at all, because in fact, generally, you got to have those things for punitive damages anyway. And in fact, the Texas statute says the standard for recovery of exemplary damages may be awarded only if the claimant proves by clear and convincing evidence that the harm results from fraud, malice, or gross negligence. So you can't even get punitive damages if you don't show one of those things. So showing one of those things shouldn't take you outside the cap, or what would be the point of the cap? So those things are listed as a predicate to getting the punitive damages, not as something that takes you outside the cap. So you meet the floor to get into the damages claim. And they did that, I think, here because the judge instructed the jury that Jones's actions, the defendant's actions, I should say, there's more than one, were intentional. She said that to the jury, that they were reckless, intentional infliction of emotional distress. She gave the instructions that they were already liable in that way. So it moves on to the damages phase of the trial, which is what we saw, which was bifurcated. So it had compensatory damages, and then it moves into the punitive damages phase. So that hurdle was theoretically cleared by the judge's default, at least as how she interpreted it. That's potentially subject to appeal, but it gets us to this damages phase and on to the punitive phase. The jury has to be unanimous on punitive damages. I think they were. There's some questions raised that there were only 10 of them signed on to the compensatory verdict. The statute says exemplary damages may be awarded only if the jury was unanimous in regard to finding liability for and the amount of exemplary damages. I kind of support the judge's reasoning there that they're talking about the exemplary damages here. So you needed a unanimous verdict, and I believe she instructed them to that, and they delivered that. And in fact, it says you have to give the instruction. You are instructed that in order for you to find exemplary damages, your answer to the question regarding the amount must be unanimous, and it was in this case. So there are exceptions to the cap, and those are defined in 41008. It does not apply to a cause of action against the defendant if the plaintiff seeks recovery for exemplary damages based on conduct described as a felony in the following sections of the penal code. So here's your exceptions to the cap. And it lists out things like kidnapping and murder and stuff like that. I don't think those things apply to this case, which is regular intentional style torts, intentional infliction of emotional distress, and here it was defamation, but it's not murder or kidnapping or the other things that are listed. So I do not see an exception to the cap here. So when the plaintiff's attorneys talk about reasonable multiples and things, that assumes that you get outside of this cap first. Just reading the statute, I haven't read any of the case law, which sometimes completely appears to contradict the reading of the statute, but I'm just reading the Texas law here. So it appears to me the cap does apply, and that means that the non-economic damages are what the cap is based on, because that's all there are, and that's a max of $750,000. So that's $1.5 million if you take both plaintiffs. So that's how I see this, is the judge is likely to remit this verdict and reduce it to the level that falls within the statute. And she even made a comment after the jury returned a verdict, they left, that the law says trust the juries, but then the law says don't trust the juries. I got to think there, she's talking about the operation of the cap, and she says, do not worry, the judgment will comply with the Texas law. So you may see this reduction coming based on that discussion. Another issue that came up, the judge was actually interrupted during jury instructions, that's pretty rare, by defense counsel, and it was during a time when she was talking about preponderance of the evidence. And they didn't elaborate because they went to break on what that discussion was, but I think that's probably based on the fact that the Texas statute, when it discusses exemplary damages, talks about clear and convincing evidence, and that's a heightened level of evidence necessary to find punitive damages. She noted to the attorney during the argument that, hey, you didn't bring any of this up at the time we were discussing all this, and I think that's because the judge had already found them liable for the intentional conduct. And I think it is reasonable to construe the statute that the clear and convincing evidence part of that applies to finding a level of liability high enough to invoke punitive damages. It doesn't necessarily apply to finding out how much punitive damages there are. I could see the arguments either way, but she basically said, this is all too late, I'm going forward with it. And she went with the preponderance of the evidence instruction. That's a problem, but I think she's right in that. It appears that way to me. The third problem is this part of the statute, which I haven't seen anybody talk about, and that is when the verdict was returned on punitive damages, it was for $4.2 million for the defamation count. That's just for Neil Heslin. And on the intentional infliction of emotional distress counts, it was equal for each plaintiff of $20,500,000. And when the judge was instructing the jury, she talked about defendants. Defendants this, defendants that. And the questions were not, that I saw, broken out by defendants. So look at this statute in Texas. In any action in which there are two or more defendants, and that's the case here, an award of exemplary damages must be specific as to a defendant, and each defendant is liable only for the amount of the award made against that defendant. So I am surprised here that they didn't break this damages award out by defendant. Okay, so for intentional infliction of emotional distress of Neil Heslin, how much punitive damages do you find Alex Jones? And then how much punitive damages do you find for the other defendant? I think one of them was Free Speech Systems or whatever. There's more than one defendant. Why not break it out by defendant as the statute appears to require? That seems to me an error in this, but I didn't hear anybody else say that in the courtroom, so maybe I'm reading it wrong, or a case has identified the language in this to mean something other than what it means to me when I read it. I don't know, but when I read through the statute, I was looking for this notion that, well, hey, if it's intentional or reckless or whatever, the cap doesn't apply, and I didn't find that. But I did find this non-economic damages argument for the cap, which other people have too. So it strikes me that this damages award is going to be reduced greatly. And if it is reduced down to $1.5 million, even if the judge were wrong on issue 3, which is it has to be specific to the defendants, and I'm not sure that gets waived by a jury instruction issue, is that really worth appealing here and maybe having this whole thing done over again? I don't know about that. If you get out at the $4 million, which Jones on his own channel appeared ecstatic about, and then punitive damages are reduced down to $1.5 million or something like that, I think you call this one good and you move on with life, right? I mean, I think he even said on his show, I'm going to work on, we're broke, but I'm going to work on starting getting that money paid, that $4 million. And he considered that a win for him and a win for the plaintiffs. So he was a lot happier than they apparently were. And maybe when the judge addresses this verdict, it may be a bad day for the plaintiffs too. It's a sorry episode all the way around. It's just a terrible situation. And I feel terrible for the parents. And if they don't understand this law and it gets applied, there may be another bad day for them. But this is my analysis of it, and since there have been some questions raised about it, I thought I would share at least where my thinking is. Thanks.